Okay, so Tally, we've been told, Rebecca Lopez told me that the judge was preparing an Allen charge.
Yeah, it's surprising that one is being developed so quickly. It makes me think that they possibly have taken another vote or two, and the holdout juror is sticking to their guns.
And so I've given my summation of how that works, but when she comes in, when the jury comes in, what is she going to say to them?
She'll basically explain to them in layman's terms that they are in the best position to make a decision, that they've heard all the evidence and all the testimony, and that they are essentially ordered by the court to continue to deliberate until a verdict is reached.
We're getting audio? Okay. Let's listen to what they're saying.
Okay, we are back on the record in cause number F1875401. To recap where we are, we have received a jury note that stated, the previous jury note that stated one of the jurors will not deliberate from her vote that was signed by the foreman of the grand jury, and the response was sent back that you will continue your deliberations. We are now up to an additional note. This note states we are hopelessly deadlocked, 11-1. That is also signed by the foreman of the jury. So at this point, the court has discussed with all parties off the record outside the presence of the jury how they would like to proceed in this manner. And so I have proposed that we send a response back pretty much explaining to the jurors what their duty is as jurors and having them to continue their deliberations. As we've discussed previously outside the presence of the jury, we are aware that they started their deliberations yesterday approximately 3:45 p.m. They took a 45-minute break around 5:30, and then we ended for the day yesterday at around about 7:45, 7:50 p.m. They then continued their deliberations this morning around 9:08 a.m. And of course, we've had the two notes that have come out since their deliberations from 9:08 a.m. until about 10:45 is when we received the additional note that we are helplessly deadlocked, 11-1. So with all of that being said and the understanding of all of that, the court once again indicated that a message be sent back to the jury indicating what their duty is as jurors, and explaining to them that we are asking them to continue to consult with one another, to consider each other's views, and to discuss the evidence with the objective of reaching a just verdict. I have proposed this language to both parties and state, did you have any objection to that response?
No.
And defense, did you have any objection to the court giving that response back to the jurors?
Well, Your Honor, before I proceed, I need to ask Mr. Chemirmir some questions. Is that okay?
Yes, you might.
Okay. And Billy, you were sworn in, and you understand. I have some questions for you. Is that right?
Yes.
Okay. You understand everything that the judge went over. You and myself, Mr. Watson, and Ms. Silva, we discussed that together. Is that correct?
Yes.
You understand that right now, basically with the last note, that the jury is saying they're deadlocked. We don't know which way that deadlock is, but they're deadlocked at 11-1. And you and I discussed what that means and the probability or possibility of which way that may be leaning, correct?
Yes.
We spoke about some strategic things in the back in regards to some things I'm about to move forward and speak to the court about. And you, myself, Ms. Silva, and Mr. Watson, we discussed those things strategically about what I'm about to put on the record, and you're in agreement with those things. Is that correct?
Yes.
Okay. And after making these motions that I'm about to make, and then depending on the court's rulings on these motions and or objections, then I will come back on the record to just solidify that what I'm about to do at that point, what has been done is what you agreed to. Does that make sense what I just said?
Yes.
Okay. Any questions of anything for me right now at this point, Bill?
No.
Okay, and you're in agreement with what I'm about to say, is that correct?
Yes.
Okay. So Judge, going back to what you said, at this point on behalf of Mr. Chemirmir, the defense, we would move for this court to issue and grant a mistrial based on the fact that this jury has been deliberating since yesterday afternoon. They did 4 hours yesterday. I believe at this point it is about 6 hours of deliberation. There were some notes sent out yesterday, really no consequence. They sent out 2 notes today of grave consequence regarding their deliberations. And just for the record to clear, the defense believes in regards to that first note that stated refusing to deliberate from her position, we believe that's a misstatement of what he was trying to convey. That he's saying that she basically won't change her mind. And he used her as the only reason I'm saying she or not. And then you sent back the note to continue. And then they sent out one, it was probably, I don't even think it was an hour from there.
About 45 minutes.
Right. That stated clearly in bold writing, we are deadlocked 11-1. I believe at this point, Judge, based on the length of time that they deliberated, taking into account that they went home yesterday over our motion to sequester, that they came back this morning, they continue to actively deliberate as a jury, and that they sent out that very strong note stating that they are deadlocked. So at this point, Judge, we're going to move this court to grant a mistrial based on the deadlock of the jury.
And based on the timing and the discussions that we have had involving the deliberations of the jury, that motion will be denied.
Okay. And so, Judge, and then regarding the Allen charge or some sort of variation of an Allen charge, the defense would also object to that at this point, Judge, for a few reasons. One would be that the Allen charge, we all know, has also been described as a dynamite charge. And that is because, in essence, what it does, and some courts have even deemed it to be coercive. And at this point, in the same way in my closing, they're deliberating. That's all that they're required to do. They're not required to reach a verdict. They're required to deliberate. We believe that that's what they're doing. We believe any sort of prompting or pushing them by way of an Allen charge or some sort of language that makes them feel as though that they have to reach a verdict would be coercive, would violate the Section 10 of the Texas Constitution, Article 104 and Article 105 of the Texas Code of Criminal Procedure, the Sixth Amendment of the United States Constitution, as well as Mr. Chemirmir's due process. And going back to one thing that we all know that jurors are not required to do, which is violate their conscience. And we believe that anything at this point where a juror feels compelled or required to change their vote, whichever way it is, we don't know which way it is, Judge, that it would violate all those things as well as their conscience. And so we're going to object to an Allen charge, in a normal standard Allen charge, or any other variation of such. As well as we believe it will violate Mr. Chemirmir's 5th and 14th rights of the 5th and 14th Amendment of the United States Constitution. And so those would be our objections to either of those.
Is there any response from the state?
No, Your Honor.
All right. So, in light of the fact that the court has denied the motion for mistrial, what would the suggestion be of the defense in regards to a response to the jurors? You have objected to any kind of quasi-language instructing them of their duties to deliberate or how they should deliberate. And is there any suggestions?
Well, Judge, I first ask if you would rule on that objection regarding if you're going to send something back, if you would rule on or
I will send something back.
Okay.
Now we have to determine, will that something be the quasi language that we discussed, or will it be you have all the evidence and testimony you've received in this case, or will it be the third option of you shall continue your deliberations?
and not to be tested around, but just for the purpose of the record, so that our objections to that would be overruled. Is that correct?
Yes.
Okay, regarding the Allen charge.
Yes.
Okay. Well, Judge, based on our objections of the Allen charge or something being sent back in some shape, form, or fashion, then we would argue or request that either there's 3 or 4.
I can repeat them.
Please, Judge.
The first one was we can send back, the instructions that the jurors have a duty to consult with one another, to consider each other's views, and to discuss the evidence with the objective of reaching a verdict. That's one. Number two, we can send back, you have all the evidence and testimony that you will receive in this case. And number three, basically the answer we sent to the first note, meaning, or the note we got previous to this, meaning that you shall continue your deliberations.
Since we've already sent that third one, that
Yes.
we wouldn't have an objection to the second deliberation.
And Judge, we would like the sentence in there, but you are not to violate your conscience in your deliberations.
Thank you.
Oh, in that one? What was it? No, the second one.
So what I just heard you state that the defense may possibly not be opposed if the court has already granted that a response will go back. So we're already there. That possibility of it including their duty to consult with one another, to consider each other's views, and with the objective of reaching a verdict. And Mr. Watson stated that the defense would like to add, as long as it does not violate their conscience.
Right, but our first option would be the request of you have all the evidence that you.
Okay.
That's our first.
Okay, I got you. State, I saw that there was,
I think option one.
okay, option one is you have all the evidence and testimony?
No, I thought the first one was the quasi. I thought that's what you had listed off as number one this last time. I think the number ones, twos, and threes have shifted around.
Number one is quasi, yes.
So I'm back to the latest
Yes.
number one, which
Yes.
I think is the quasi of, you shall continue to deliberate, and that, it's kind of a watered down
Yeah.
county charge, is the way I
Yes.
kind of view it.
Okay. All right, so this is what the court proposes in regards to marrying the two together. It is your duty to consult with one another, to consider each other's views, and to discuss the evidence with the objective of reaching a just verdict, as long as it does not violate your conscience. Is that close to what you said, Mr. Watson?
Could you take out the to discuss part and just to consider all the evidence?
I think deliberate's got to be in there.
Yeah, discuss has to be. I mean,
But no, well, they don't, discuss involves them continuing to debate. And I think discuss invites one person to be beat down by the other 11. And deliberate encompasses considering the evidence and discussing.
So you would like to change the word "and to discuss" to "and to deliberate the evidence"?
Yes.
I don't think that's grammatically correct, but I understand. And so in going to the next portion, as long as it does not violate your conscience, is that part, the part you want, as long as it does not violate your conscience?
Yes, ma'am.
All right. So I will allow the word "discuss" to stay within the sentence, because I think that is what we're trying to get them to do, is to discuss. So, go ahead.
I'm sorry, Your Honor.
Mr. Warren?
I'm sorry. Can you read the first part again?
Yeah. It is your duty to consult with one another, to consider each other's views, and to discuss the evidence with the objective of reaching a just verdict.
That's the part
Okay?
I would strike that last part, because they are to deliberate.
So you could say to deliberate about the evidence or
Right,
something like
but-
that.
Discussing the
If you want to use
evidence.
the word deliberate instead of
But-
discuss.
Like, I don't care about that,
Yeah.
but. the
We're talking about
language
that part, objective of reaching a just verdict.
Correct.
So you would like that to say what?
They just need to continue to deliberate.
But I think that's in the charge. They're supposed
It is in the charge.
To get a
That's
just charge.
sufficient. It's in their original charge, so in this quasi-island charge, I object to that language being in there.
So, and to discuss the evidence,
Yeah, to deliberate and discuss the evidence.
it is your duty to consult with one another, to consider each other's views, and to discuss the evidence. Because deliberate's nowhere now.
And continue to deliberate.